Ready, start. The primary contention, which was canvassed on behalf of the appellant and writ petitioner, was that insofar as scheduled caste, scheduled tribes and OBC candidate are concerned, the prescription of a cut-off date for the production of caste certificate is wholly superfluous and of no significance whatsoever. Full stop. It was submitted that a caste certificate is essentially a status already obtained and held by a candidate belonging to the aforementioned three categories. Full stop. It was sought to be contended that the caste certificate was not a document confirming a particular status, and upon this submission, it was submitted that a candidate belonging to the scheduled caste, scheduled tribes, or for that matter, the OBC category acquire that status by virtue of belonging to a particular caste, category, or group. Full stop. The certificate, therefore, it was submitted, was in essence a certificate of an already existing status. Full stop. In this view, learned counsel submitted that even if the caste certificate was submitted after the last date prescribed in the advertisement, the same could not be refused. Full stop. It was further submitted that the prescription of a last date for submission of such a certificate clearly did not prescribe to any, in as such much a holder of the said certificate belongs to the particular category even before the date prescribed in the advertisement and even thereafter. Full stop. It was then submitted that such a prescription being read into the provision of an advertisement or recruitment notice could not only be an arbitrary but also the constitutional guaranteed unreached in Article 14, 15 and 16 of the Constitutions. Full stop. In so far as question number 3 is concerned, the issue itself came to be formulated in light of the submission advanced by learned counsel that there was no refusing between the criminal standard stipulated by the state and the union government. Full stop. It was sought to be demonstrated before us that the benchmark formulated by the union government were lower than those prescribed by the state, and therefore merely because the certificates produced were with reference to the appointment to post under the government of India, and the same could not be discarded by the state responder. Full stop. Para. The learned Chief Standing Counsel appearing for the state our attention to the provision of the advertisement to contend that all the participant candidates had been put to adequate notice that a caste certificate was to be obtained and submitted in a prescribed format. Full stop. He further contended that the advertisement not just prescribed time limits within which a caste certificate on the prescribed format was to be submitted, but also stipulated the consequence of a certificate not being submitted within the time fixed thereunder. Full stop. He further sought to highlight the fact that for the 1865 vacancies which came to be the advertised, the board received as many as 41,000 applications. Full stop. It was his submission that in the recruitment process as many as 391, 37 and 503 vacancies stood identified as being reserved for the scheduled caste, scheduled tribes and OBC candidate respectively. Full stop.